All right, we want to welcome everybody to this live stream today. My name is John Skiba, and I'm a consumer protection attorney and a bankruptcy attorney in the state of Arizona. And I'm joined today on this Q&A session with John Watts, who is also a consumer protection attorney in the state of Alabama. And I'm going to have him introduce himself in just a moment. I just wanted to let everybody know what the purpose of this session is today. We want to address questions that people may have about financial issues that they're dealing with. We're recording this during the COVID-19 pandemic. And, I was reading an article today that said a full 50% of American households are experiencing some type of financial stress, whether it's a complete job loss or even just reduction in hours that's causing a real financial struggle at home. So this is impacting a lot of people. I know a lot of people are concerned about what the future holds. And I can tell you in my 18 years of law practice, I realized the one thing that can help to reduce the stress is to have a plan, to understand what the consequences may be, and just generally what we're going to be doing forward. So if you have questions, go ahead and put them in the comments. We're going to do our best to respond to them as we go through this today. And before we jump into that, John, why don't you introduce yourself and let everybody know a little bit about your practice and what areas you focus on?
Sure. Well, it's good to see you, John, and I appreciate you having me on here. So like you, I am a consumer protection attorney. I'm just on the other side of the country in Alabama. And so what we do is typically we're suing debt collectors, credit bureaus, mortgage companies, and we're defending people who have been sued, and really just anything that involves protecting consumers. So it could be somebody's negligence harms you, that's what we do, or dealing with the IRS on back taxes, just again, anything with consumer protection. And John, like you mentioned, with this COVID-19 thing, it's almost like a hurricane has hit the entire U.S. or the entire world. So many people are being affected from every walk of life. And so I think what you're doing here is very important.
Well, and I appreciate that. And just so everybody out there knows, I also do bankruptcy practice. So if there's questions related to bankruptcy, but I also deal with debt collection lawsuits and those types of things. So to start this off, John, why don't we talk about you and I both practiced law during the Great Recession, 2007, 2008. How does this feel different to you? Is this going to be different? Any projections or thoughts as we're kind of just getting into this downturn in the economy?
Yeah, well, it certainly feels familiar in the sense that we're seeing so many people laid off and seeing the real estate market. Maybe it hasn't crashed yet, but it certainly has stalled out, at least in a lot of parts of the country. And, I think you and I are both in a situation where we can see some parallels with what happened before, and we don't want to ignore what happened before. But this is also different. The last recession, it was a couple of industries kind of crashed the economy. And here it's something completely from the outside. And so I think it's affecting a lot more people than what we saw in 2007, 8, 9, 10. But we'll still see some of the same problems where, if you just don't have enough money to pay for your house, for example, and if the value of your house is crashing, it's kind of hard to keep pouring money that you don't have into a house that is no longer worth what you owe on it. And I'm curious, John, what you saw in Arizona back in the Great Recession with debt collectors. Did they seem more aggressive, less aggressive? How did they seem during those years when everybody was really struggling?
The 07, 08 was really the uptick in, I think nationwide, the uptick in debt buying, where we saw the portfolio recoveries of the world, the Midland fundings of the world. Really, if you look at the stats, the number of lawsuits that they were filing nationwide just exploded. And we saw that in Arizona, where I saw a stat once that they were filing 10,000 lawsuits a month in the Phoenix metro area. And I think you're right that last time in Arizona, we were dealing with real estate issues for the most part. This does feel different already in that it impacts every segment. I recently had a consultation with a nurse. I had one with a physician's assistant where they're losing their jobs because there just isn't the patience there because everything is shut down completely. So I'm postponing any kind of judgment right now on whether there's how the debt collectors are going to work. I haven't seen a change as far as them being willing to settle or postpone things. Some of our courts in Arizona are at least not processing garnishment orders like they were before, which I think is a product of both the courts being shut down and not being able to process it, just physically process it, and also to give people some breathing room on this. But so I'm not seeing a big change at this point, but I'm assuming they're eventually going to have to get aggressive because the debt collector's goal in life is to collect money, and if they're not getting money, they've got to figure out other ways to do it. So
right, and the situation is as more people struggle, and that goes on longer and longer, then each person has sort of fewer dollars that they can spend on collectors. Well, if there's more debt out there and more collectors that are trying to get those fewer dollars, there's going to be the temptation. Some debt collector is going to say, if I kind of cut corners, if I get a little more aggressive, maybe I push the envelope, I can get that money instead of my competitor getting the money. And so that's what we saw, at least in Alabama. And I mean, there's an explosion of debt buyer lawsuits, just like you mentioned, Portfolio, Midland, those guys. But just calls and letters and, calling your neighbors and your coworkers and just trying to put that pressure on. I mean, right now, I think everything is pretty calm. Most debt collectors I've seen are taking kind of a hands-off approach, like, hey, let's not be blowing up somebody's phone during a global pandemic. But, that's going to change. And when it changes, I think it'll change pretty suddenly.
Yeah, I think a lot of them are not working at home right now. So, well, why don't we? There's a question here. Why don't we go ahead and talk? This one has to deal with the statute of limitations. Do you want to address this one, John?
Yeah. So, do statute of limitations on debt stay the same or change with courts being shut down? That, Kim, is a fantastic question, and I'm going to give you the answer for Alabama, which may be a little bit unique, at least in talking with other lawyers around the nation. So our courts are actually not shut down. So it's weird. They're open, but the public can't go in there. So there's been no effect on statute of limitations. So whether it's a personal injury case, whether it's a debt collection case, if somebody's statute of limitation ran on March 30, they better have filed their case by March 30. Now, I know in a neighboring state, Tennessee, there was a kind of a shutdown of the courts, and they said that will extend the statute of limitation. So I think it really depends on what state you're in. So Alabama, it's like nothing has changed. I don't know, John, about you in Arizona.
Yeah, I think the answer to that question is going to be pretty state specific. In Arizona, the courts, it's similar. They're open, but not to the public. I actually had a trial that was scheduled yesterday against Midland Funding, and we hadn't heard anything about it. But I called down there and got voicemail, and they said that we're closed. But I called back again, and I think I was getting a clerk who was working from home, and they said that, no, we're in Arizona. The courts are open. They're not doing any hearings until June 1st. Right. So I would agree with you. I think it's a good point that if the statute of limitations, if it's close to expiring and they don't file their lawsuit timely, assuming that the courts are open in your state, and the definition of what's open, I guess, is going to be what the difficult thing is going to be. They're still going to be required to submit that.
Yeah, and John, just one last thing, for you to think about, Kim. There's an argument to be made, at least in some states, and I don't know if this will work or not, and it'll help some people and hurt some people, but there's an argument to be made that the Supreme Court of the state cannot extend the statute of limitations. In other words, that's the legislature has created these certain time periods and the courts can't change that. So, there's going to be litigation over that. And so if you get sued and somebody, quote, missed the statute of limitation, but they're counting on being extended, that may be an argument that you have to say, well, wait a minute, you really can't extend the statute of limitation in your particular state. So just it's a little bit of a technical argument, but you may want to keep that in your back pocket.
Yeah. Let's jump to another question here. This one has to deal with something, John, I think you're the expert in here, is repairing credit. Do you want to touch on this about repairing your credit while you're in a current Chapter 13 bankruptcy? I have some thoughts on it, but I'd be interested to hear what you have to say on it.
Yeah, so I'll say this for everybody involved in credit reporting. Chapter 13 can be a little confusing. The mortgage companies are confused, debt collectors are confused. I think probably the best way to handle it is to definitely do it after you get out. Now the question is, should you do it while you're in there? I think if you can look at your credit report and see actual errors. So I'll give you an example. There's an account that you paid off, and it should be a zero balance, but it's showing that you owe $1,000. Well, if you paid it off, then yeah, dispute that. But for most creditors and debt collectors, they kind of freeze the credit reporting during a Chapter 13, at least what I've seen, because there's so much uncertainty about what are they supposed to do. In other words, are you current or are you late if you're making your payments into court for Chapter 13? And, so John, you may want to talk about that because I don't do bankruptcy. So I get people after a Chapter 13 and then we help them with their credit, but you deal with it sort of in real time.
Yeah, the surprising thing to a lot of people is, because there's Chapter 7 and Chapter 13. Most people file Chapter 7. That's the process that eliminates all the debt. It's relatively short, takes about 4 to 5 months to process, as opposed to a Chapter 13 where you're required to pay a portion of your debts back over a 3 to 5 year period. And so it seems a little backwards, but what I see often is people's credit score recovers more quickly in a Chapter 7 just because it's over. It gets done in 4 or 5 months, and then you can move on from it. I've seen mortgage lenders like FHA, I believe it's 2 years from the date of discharge. They'll reconsider you for like a mortgage loan. Some of the other lenders are 3 and 4 years. Where at Chapter 13, the tough thing you have is kind of what you were mentioning. You're in an active bankruptcy case for up to 5 years. That's not to say that lending can't occur. I've seen car loans with actually surprisingly decent interest rates that people have been able to obtain while they're in a Chapter 13. But I agree. I think probably if you're looking just to repair it all, it's better to wait until the discharge is entered. They'll update the accounts at that point once that is finally entered, showing the zero balances. And you're probably going to have a better overall result if you wait until that's over. But that's a tough one because it's a long process, and you're gonna have to wait all the way to the end of that, I think, to really get what it is that you're looking for there. So, okay, let's this one is specific to Alabama, so we'll pass this one, and it's a 2-part one here, John. Okay. Is that Etowah County? Am I saying that right?
Yeah. Yes. Okay. At least that's how we say it.
All right. So we have a portfolio recovery lawsuit that's been filed. Received a letter saying that due to COVID situation, they'll not be served until April 30th. Should I be concerned?
Yeah. So, Michael, what that's talking about is, so again, it's sort of weird with our courts. They're open, but there's no hearings for the most part. There's no trials through April 30. So, for example, I have trials starting Monday, May the 4th. Maybe those will get moved, maybe not. But I think what's happening is a lot of times you're being served by the sheriff's deputy, and that's where they come hand you the papers. And they may be saying, we're just not going to do it. Or even a private process server, just because of safety concerns, is not going to knock on your door. You open the door and they like throw the papers from 6 feet away, So I think that's what the letter you're referring to is, that, everything's just kind of on hold until April 30. So, and I know I've talked about this in other videos. If you've been sued, maybe you're getting advertisement letters or something like this, definitely get prepared for it. And whether that's go ahead and file an answer, and it's a little bit controversial, that's the position I take, is better to go ahead and answer and fight this thing head on rather than waiting to be served, because they may claim they served you and really they didn't, and then you got to fight that whole process. So, but it's probably legitimate. And Michael, just get with my office and we can look up that case and make sure that there really is a case filed against you, and we can give you all the details on that. So be happy to do that.
You mentioned one of the things that I get a lot of grief from people online and on my YouTube channel, and it relates to people trying to dodge service, where that there's a process server that's come by the house, or you receive something in the mail, and some people believe and take the position that, hey, if I just avoid this, that eventually the whole thing will go away. I take the exact same position you do, that it's better to just accept this and let's deal with it, because there's some strong defenses, particularly to debt buyer cases, that people can put forward and try to get this thing dealt with. Whereas in Arizona, what happens if you don't accept service, they go to the court, they file a motion for alternative service, and the judge will then allow them either to just mail it to you. In the old days, they could put it in the classified section of some random newspaper somewhere. So you were never—
We still do that. That's what happens in Alabama.
Okay. And it always seems to be the smallest
right.
newspaper in the entire state, in some city with 2,000 people in it, and you never see it. And then they end up with a default judgment, and then they wake up to their bank account being swept or a wage garnishment, and you didn't even know what happened. So I agree with you 100% on that. My recommendation, if there's a creditor out there that is lurking, or you've seen online that they filed a lawsuit, definitely better just to get it and deal with it head on, because eventually something bad's going to happen. And putting together a plan is definitely the way to deal with this.
Right.
So, well, let's talk about, you talked about that you had seen collectors, and you're anticipating collectors starting to get more aggressive. What can consumers do and I guess we should maybe talk about what the rules are. And we're talking about FDCPA stuff. Fair Debt Collection Practices Act has some regulations that are imposed on certain collectors. What are some of the most common things that you see in your practice as far as what rules are violated by debt collectors? And if that happens, what's your general process?
Yeah, so there's a couple things that we'll see a good bit of. False credit reporting is one. So, maybe you owe a debt for $1,000, but they put it as $2,000. Well, that's illegal under the FDCPA, Fair Debt Collection Practices Act. But the sort of more personal stuff would be calling all of your neighbors. And in the industry, this is known as a block party. Okay, they say, hey, I'm going to do a block party on John Skiba. That'll make him call me. So they call all your neighbors around you, and they don't say you owe a debt. But so, like, if I'm a collector collecting against you, John, I'd say, call your neighbors, say, hey, have you seen John Skiba? I'm sort of worried about him. Can you give him a message to call me? Oh, sure. Well, you have about 5 neighbors come up to you. Now, I don't know how this works in social distancing, but 5 neighbors come up to you with a little sticky note, or they're texting you, and it's like, oh my goodness. Well, that's just utterly illegal. Those are, just from a lawyer's standpoint, those are fantastic cases. We love suing debt collectors for that. Same thing with calling all your coworkers. They call that an office party. So those, what the law calls a third party contact, those are some of the most damaging types of abusive debt collection. And when we sue the collectors, what they say is, well, I mean, it worked. I couldn't get Skiba to answer the phone, but boy, when I called all of his neighbors, he really answered. And our response is, well, if you kick down the door and shoot somebody in the knees with a shotgun, that works too, but it's illegal. Yeah. So what I would suggest people do is, it maybe I'm wrong on this. Maybe the debt collectors are going to be just perfect for the next 3, 4, 5 years. I don't think so. But if I'm right that they're going to get very aggressive, you've got to learn your rights. And, what we're doing here is part of that. Read the law, talk to a lawyer. And then when you have a question about it, get with a lawyer in your state who does this type of work to be able to say, hey, are these guys violating the law, or what can I do? And the last thing I'll say is just document things. Okay. So if your neighbor says, yeah, I got this call from somebody, well, hey, can you send me an email or a text with the information? And, if a collector starts cussing you out or yelling at you, make notes about that. document everything is really an important thing.
Something I see, and you can tell me what you do in this situation. Often I see that the more egregious the behavior of the collector, the more difficult it is to actually find someone
Right.
hold accountable for that. And I don't know if there is a solution. I remember one time we filed suit against a collector that was doing even worse. I mean, literally threatening him with jail, and that they were sitting outside their home, and just egregious type tactics. We found the company in the state of New York. We filed suit here in Arizona. Literally, they shut down and moved to a different location. It wasn't a large operation, but is there anything when things are, I think it's always good to talk to an FDCPA attorney if you're getting that kind of behavior, but is there anything to do? I guess this is more of a question for me. what do you do when the off the charts kind of stuff of collectors that are actually difficult to track down?
Yeah, that's a huge problem. And like you said, as the sort of the craziness of the collection goes up, the likelihood that that's not a real company goes up.
Yeah.
And so what I've always recommended people do, and this doesn't, allow us to sue the bad guys, but this will make the collection typically stop. When somebody's saying, "Hey, I've got a warrant for your arrest at the sheriff's office or DA's office," say, "Well, send me something in writing. Send me a letter." And usually they go, "Oh, no, it's too late for that. We can't do that." Go, "No, send me a letter." They go, "Okay, what's your email?" No. I want a letter in the mail. They go, "Well, I'll fax it to you." Go, "No, I want a letter." These scam guys will not send letters through the mail. They're worried, I guess, about mail fraud, crossing state lines. And usually if you just sort of stick to your guns about that, or if they say, I've got a warrant, down at the sheriff's office, DA's office, say, "Well, tell me with who. I'm going to call them and find out."
Yeah.
And they won't do that. And usually they move on, but we've not been successful in figuring out, the guy that's, in a basement with a prepaid cell phone.
Yeah.
I don't know how you get any money out of that guy.
Yeah. Well, let's take a look at this question, which is kind of a debt collection and credit reporting. So someone on their credit report, it shows there's a debt for $1,050, but now they have a garnishment for $5,900. Why don't you take the first stab at that, and I'll give some of my thoughts as well.
Okay. Well, this is probably true of most states, but in Alabama, there is, you can be sued for a certain amount. Let's say it's $1,050, but then there's going to be court costs and attorney's fees added on top of that. And now they have this judgment. And as that judgment continues to progress through time, it gets bigger and bigger and bigger with what's called post-judgment interest, so judgment or interest after the judgment. And so, we've seen amounts be, many, many times the amount originally sued for. Now, it would be a little odd for that to happen just because of some timing situation. So negative credit reporting should only be on there about 7 years. And that's probably not enough time for this thing to grow to $5,900. So I'm not sure how the garnishment got that big. Maybe there was a lot of attorney's fees or something else, but Carly, if I was in your situation, it would be worth sending a letter to the credit bureaus and to whoever has that, whoever's doing the credit reporting, saying, "I'm confused because, why are these different amounts?" Now, if you think there's a chance that they're going to change your credit report to $5,900, then you may want to not say anything so that you don't have it higher. But you can always go to one side or the other, go to the lawyer with the judgment and say, "How's this $5,900 if my credit report's only $1,050, or the opposite?" And just try to get some clarity on that.
In Arizona, what we see the situation a lot because usually the judgments, particularly if they're a default judgment, and most, I believe the statistics are 94% nationwide of debt collection lawsuits end in a default judgment, which goes back to our prior answer. You got to do something. You got to respond to this if you get sued. But if there's a default judgment that's entered, often there's that contract rate of interest. So in Arizona, we'll see these default judgments that will have interest rates of 29%. And so they just churn interest. And in Arizona, it used to be that civil judgments were good for 5 years. our state legislature, in their infinite wisdom, amended this, or and now they're good for 10 years. So, and then they can be renewed every 10 years for the rest of your life. And so it's not, uncommon. I'll see a judgment out there that's been churning interest at 29% for 8 years. And then they finally come in with a wage garnishment or a bank levy, something like that. So that's my guess as well. Is there's probably some interest, attorney's fees. A lot of the attorneys here will seek a post-judgment collection fees on top of it, and that whole thing can turn into just a giant nightmare. And that's why, again, it goes to the point that is so important. If you think you're being sued, or even if you're not being sued, if there's just an account out there, to reach out and do something and put some kind of plan together to deal with it, because these things can just turn into a nightmare. I talked to a guy a while back, and he told me a story about, he called it his $500, I think it was like a corn dog or something, where he went to a fair and he wrote a check. He was like 19 years old. He wrote a check for this corn dog, and the check bounced. And anyway, so they sent it to a collection agency. And when it was all said and done, with interest, with fees, with the court costs, the whole thing turned into a $500 debt that he ended up paying. Not saying that the process was followed correctly there, but it can become a huge issue. So the main thing there is to make sure that you're putting together a game plan.
Yeah, and John, if I can just say one more thing to Carly, is when we see these judgments get so big, and sometimes people are garnished and they're making payments in, and the judgment continues to grow, it may be that the interest is just so high that you're not making any progress. But sometimes these collection firms will really mess it up, and so it is worth looking at and trying to dig into it to say, okay, did they do the right interest rate? Did they apply the right fees and costs and expenses? Because most states have a provision where if there's a wrongful garnishment, in other words, a garnishment that is either in its entirety improper or in part improper, then you may have a claim back against that creditor. So, what you're describing here, it just looks wrong that there'd be that big of a discrepancy. So I would definitely look at that.
Yeah. All right. This next one, saying that the person has been sued by a bank, been to court 3 times. Now they're getting a letter addressed to the court stating that they don't have an account for me.
Well, that seems a little awkward for the bank.
Yeah. What are your thoughts on that?
So, I guess I'd sort of, Jerry, make sure I'm understanding this, that, you've been sued. Sounds like you've had some either court hearings or trial dates. Maybe they get continued, and now the bank is saying they can't find the account on you. That ought to be really good for you. Okay. I would think that would put you in a very strong position to get rid of that lawsuit. And at least in Alabama, and I think in most states, if you're successful with your lawsuit, so you get a judgment in your favor, or if they dismiss the case with what's called prejudice, which means the case is over, it's done, then you may be able to take that and look at your credit reports. And if that bank has some credit reporting on you, go dispute that with the credit bureaus and say, look, here's the order, or even here's the letter from the bank saying they can't find an account on me, and send that to the credit bureaus and see if they will take that off of your report. So you may be able to get rid of this lawsuit and get rid of the credit reporting on that. So that's I think a very good situation for you.
I would add to that as well. In a state like Arizona, if you obtain a judgment, if you win your civil lawsuit, if you're the prevailing party in Arizona, you can ask for any attorney's fees and costs that you've spent. So if you had a lawyer, if you had to pay the filing fee, those may be fees that you can get back out of the process through a judgment of your own. I would also say, something that, when I see stuff like this, immediately I start thinking of FDCPA claims, but, and I don't do that practice area a lot. So John, you're going to correct me if I get this totally wrong, but I think something that's important to bring up is generally the FDCPA statutes, which would govern if they're, bringing a suit that they don't have a basis to bring, only applies though to collectors, not to original creditors. Do I got that right, John? Make sure we're good. Okay. So if this is the bank, if this is Bank of America that's suing you, and it turns out that they don't, they just totally dropped the ball and they don't have the account. I don't know if that would even bring up any type of FDCPA liability. What do you think?
So maybe two thoughts about that. One is the collection lawyers would be subject to the FDCPA because they're considered debt collectors.
Yeah.
If they bring a suit that they know or should know has no basis, that's a problem for them. And then check your state. I can tell you in Alabama, we don't have anything that applies to the original creditors. And John, I don't know about Arizona, but take Florida, for example. They have a state version of the Fair Debt Collection Practices Act, and it applies to original creditors. So you can sue a bank for that. I think maybe Texas has something called like the finance code or something like that. But so I don't know what state you're in, Jerry, but I would just check your state because you may have some ability to sue the creditor. And if they're admitting now, or if they admit in court that they never had an account on you and they had no basis to bring the lawsuit, again, that may give you an angle to go back after them and recover some of the costs that you've incurred.
Let's switch gears just a bit. I wanted to talk about the CARES Act, this new legislation that's come out that is geared to help consumers in different areas. One area that I think a lot of people are going to be helped by is the credit reporting part of the CARES Act, which states that if any of your creditors give you an accommodation, so if you can't pay your credit card and I believe, and again, John, correct me if you understand this a little better, but like consumer debt, like a car loan, if there's some type of accommodation where you call them up and say, I've been impacted by COVID-19, I've lost my job, I've had reduced hours, and I can't pay right now. And they say, hey, we'll give you 90 days forbearance type thing. That if you are current at the time that they give you that accommodation, they're not allowed to report to the credit reporting agencies that you're behind. And I think that's going to be, now I know that we've talked about this and you think this is ripe for litigation down the road, I believe. But to me, that seems that's, at least on its face, that can give a little bit of comfort to people that if you're behind, and again, going back to making sure you take some action, if find yourself in a tough spot, you may be able to buy yourself some time and not negatively impact your credit score.
Yeah, I think it's a fantastic part of the law because, a lot of times we think of this CARES Act as really applying to mortgages, and it does. But what you're talking about, John, is any creditor or debt collector, anybody that reports to the credit bureau. So it could be a car loan, it could be a place you're renting if they report to credit bureaus, it could be a credit card. So like John's saying, reach out and say, hey guys, I need some help. I've been impacted by this, job loss or whatever it is. And if they give you any accommodation, and the law is very broad, it just says accommodation. And so if it's, hey, you can skip 3 payments, or you can make half payments, or you can send us $5 a month, whatever they say, if you're current when you get that accommodation, they have to report you as current every month during that accommodation. And that could be 2 months, 6 months, however long it is. And that's a great benefit. But, I think we're not being too much of, looking into our crystal balls to realize these companies are going to mess that up. And you're going to get 90 days and all of a sudden, boom, all these things are hitting your credit report that you're 90 days late. And you're like, wait, you gave me an accommodation. And that's when you, again, I guess the whole theme of this, John, is you got to take action, right? Then you'd want to dispute through the credit bureaus and things like that. But just definitely keep that in mind. And last thing I'll say about that is if you are able to get that accommodation while you're still current, because then all the period of that accommodation, they have to report you as current. So better to call on day 29 and get the accommodation, because at day 29, unless my math is wrong, you're not 30 days late, than to call on day 30 because now you're 30 days late.
Yeah, you can see how that is going to play out. The hard thing with this is if they don't report it correctly, that's a hard thing to unwind. The damage is going to be done, and to try to get that fixed could be difficult. What do you recommend if a client comes to you and they want to dispute something on their credit report. If you go to the big three, Equifax, Experian, TransUnion, they have online versions that you can log in and dispute it. I've seen other people who recommend that you only do it with a physical letter, a paper copy. Do you have a recommendation as far as which one's more effective, or which route you generally recommend people take?
Yeah, so generally we recommend people do it by paper. So send it certified mail. But if I take a step back, the reason for that is so you can prove what you sent. Now, you can do it online, and I've started having clients do this. So you're going through the online, and you take a screenshot of every screen. Or even better, just get some free software that'll do like a screen recording. And once you log into Equifax, Experian, TransUnion, whoever, just record that as a video. Because what happens is you will put things in there and you'll upload documents. And then later in litigation, Experian will say, well, you never told us that. They go, yeah, I typed that in. They go, no. That data was lost. We don't think you did that. They always lose the data that's helpful to you. Okay. They never have a computer glitch that helps you. It only hurts you. Yeah. So you could do it online, but I see people say, well, it's so much easier online. It is, but you got to document it. And so get that screen record, or, take, 100 different screenshots as you go through the process, and then save that, put it on Google Drive, Dropbox, somewhere, in the cloud. Because I have people come to me and say, I have the perfect evidence. I go, can I see it? They go, well, I dropped my phone in the toilet and now it's, all the data's gone. And so don't do that. I mean, don't drop your phone in the toilet, but don't only have it on the phone also. Yeah.
What could have been.
Right.
Well, I thought, I wanted to just touch on bankruptcy briefly and do a last call for any questions that they want us to address. And then we can wrap this up for today. I did want to reach out just because I do get a lot of questions about bankruptcy. Bankruptcy is one of those things that I always say nobody wants to file for bankruptcy, but it's a pretty powerful tool if you find yourself in a tough spot, and particularly if you have wage garnishments going on, foreclosures. And that's why you're seeing so many articles out there where they're predicting that there's going to be a lot of bankruptcies in the future, because if people aren't working and they're not making house payments, even if you have a forbearance, John, I think we had talked about, you had said that there's these government programs, and even some of the lenders are giving forbearances on mortgage loans, but eventually you're going to have to get caught up. And right. So, if you go 12 months with no payments, at the end of that 12 months, unless you've received some kind of loan modification, the balance is still there, and they're going to want you to get that caught up, or you're going to run the risk of foreclosure. But the same with car loans. I'm seeing a lot of the car lenders are providing forbearance periods, 1 to 3 months, where they're allowing you, where you're not making the payment, but eventually those payments are going to have to be made, and then you'll run the risk of repossession. Same with credit cards and everything else. So I'll just do a very high level difference between the two chapters of bankruptcy. Chapter 7, and I touched on this briefly before, it's really designed to eliminate unsecured debts like credit cards, medical bills, personal loans, debts where there isn't collateral, there's no property attached to it. Those debts generally go away. There's a couple exceptions. Student loans generally don't go away, and most taxes don't go away. There's exceptions to those rules, but as a general rule, those aren't going to go away. Secured debts like your home loan and your car loan, they are not really impacted like unsecured debt is. If you want to keep your house, or if you want to keep your car, generally you just need to continue to make those payments. But those don't go away. I've had people say to me, hey, I'm going to file Chapter 7, get rid of my mortgage and keep my house. I wish it worked that way. It doesn't. So you're going to have to continue to pay on anything that you want to keep. With a Chapter 7, if you have assets that are not protected by exemptions from your state, there's also some federal exemptions. Most people are familiar with the homestead exemption. In Arizona, it's $150,000. What were we saying it is in Alabama, John?
$15,000.
$15,000. I was outraged.
It used to be $5,000. It used to be $5,000.
Yeah. Well, at least your home's protected if you live in Alabama. When you told me that was one of those things I even thought later. I'm like, that's incredible that it's so low. So that in Arizona, this is a pitch if you want to move to Arizona, up to $50,000 of equity in your home is protected, or you can move to Florida where there's no limit.
Right.
So the in a Chapter 7, if you have non-exempt assets, the court's going to take them, sell the asset, and give the money to your creditors. So the trade-off is you're getting rid of all this unsecured debt. The downside is if you have assets that are not protected under the exemption laws, you could lose them. That being said, it's around 95% of Chapter 7 cases. They're what we call no asset cases. There is no distribution of assets. So, and it's about a 4 to 5 month process. The big picture on the Chapter 13, much longer process. It's 3 to 5 years. The ideal candidate for a Chapter 13 is usually somebody who's behind on their mortgage and they need some time to get caught up. So if, let's say you're in a forbearance for 6 months, there's this big chunk of money that they want from you. If you go into a 13, the court initially puts an order that stops collections. So they can't foreclose. They can't even call you on the phone or send you snotty letters. Everything stops. And then you're able to propose a plan of how you're going to get that caught up over the next 3 to 5 years. So that's typically the people we see file for Chapter 13 and the people who don't qualify for 7 because they make too much money. They're going to look at your household size and your income, and it's a means test where if you make more than what's allowed for a family of your size and your state, and it varies from state to state, and they update these numbers quarterly. So with incomes coming down, we're going to see those numbers adjusted when they release the next means test numbers. But if you make more than that, then you're likely going to have to file a chapter 13 rather than a 7. So it's a much longer process. You do have to pay your creditors back some of the balance that's owed. But at the end of the Chapter 13, any balance owed on the credit cards, medical bills, all of that's eliminated at that point. There's a lot of twists and turns in both of those cases, but that's just generally what you're looking at as far as the bankruptcy process.
Now, let me ask you about bankruptcy. So let's say I'm looking at bankruptcy and, January, February, my income was too high. It was above that means test, but now I've lost my income. If I think I'm going to be employed again at some point in 6 months, would there be an advantage to trying to get in and file a 7 now while my income is down? In other words, how far back do they look to figure out? I mean, is it your current pay stub? Is it the last 60 days? What is it?
Yeah. So how they calculate the means is they look back at the prior 6 months prior to the filing of your case, not counting the month that you file in. So we're recording this at the end of, if you were to file a Chapter 7 today, I would have to calculate your income from March 31st back 6 months. And so there is a benefit if you have job loss, if you have a reduction in pay, and because it's average, more months you're in that situation, the more likely it is you're going to qualify. And so they're in situations like this, when we saw this in 2007, 2008, there were windows of, I don't know if I want to call them opportunity, but there were windows where it was much easier to qualify for a Chapter 7 because of a loss or reduction in pay, when normally a Chapter 7 wouldn't have been possible. So that's something to look at if you think that you're worried this may be down the road, or at least an option you're considering. You need to see if you qualify. You'll likely need to talk to an attorney locally. Most bankruptcy attorneys offer free consultations, and they can give you a good idea if you're going to qualify. There's a lot of calculators out there, like online calculators for the means test. A lot of them are not good as far as being able to estimate whether you're going to qualify, but it's a good question.
And I don't do bankruptcies, but bankruptcy lawyers will send me cases in bankruptcy court, litigation cases. But what I've noticed is it seems like it's a very local practice. In other words, what we can do in this courthouse, you can do a Chapter 7 here, but the same thing in this other courthouse, no, it's got to be a Chapter 13. So again, sort of summarizing this whole conversation is, you've got to understand where you are and what your options are. And so if you go meet with a lawyer, and the lawyer who does bankruptcy says, you don't qualify because you're just slightly above that means test, well, then ask the question, if my income stays the way it is, will I qualify next month or 6 weeks from now? Because again, there may be that window of opportunity to get some good relief. This is, I know, John, we've talked about this, not in this video, but just offline, about, if you have old tax debt with the IRS, well, what they're looking at is your income, your expenses, your assets, your net worth. Well, the best time to approach the IRS to get a good deal is when your income is down, your assets are down. And I suppose to some extent, same thing with bankruptcy.
Yeah, even with the Chapter 13, because if they're trying to determine in the Chapter 13, the idea is they're going to look at your income, your expenses, and look to see, is there any money left over at the end of the month that can go to your creditors? And so, I mean, that disposable income, that's what they're going to be looking at, is how much you're going to have to pay. And in a Chapter 13, it's fluid. If your income goes significantly up or down over that 5-year period, the amount you pay your creditors may go up or down. But I appreciate what you said. It's very kind of it's a federal statute, but it is fairly local. I'm always hearing things in different districts that happen with bankruptcy, or the way that the cases are handled, that it is surprisingly handled differently. Even in the state of Arizona, there are different trustees, and they all deal with things differently, just to make life complicated. So, well, why don't we? There's one. Why don't we end with this question here that Cedric has? This is another credit reporting question. John, you want to tackle this one?
Yeah, so it's a good question, Cedric. I'll give you the short answer, then the slightly longer answer. The short answer is most original creditors. Well, let's see. Let me make sure I'm reading this right. If I pay the original creditor, will the collection remove it from my credit report? So if the original creditor is reporting, let's say $5,000 on your credit report, and you go to the original creditor, we'll call it Bank of America, and you settle with them, normally they will not remove it from your credit report. Now, they've got to show it as being zero, because you don't owe anything after you settle it. But if you're talking about a debt collector has it, sometimes you can get the collectors to remove it. Oftentimes this is called a pay for delete. So I pay you money, and you, Mr. Debt Collector, will delete it from my credit report. And if you go that route, you just want to make sure that you have it confirmed with them that they actually will do it. And then whatever the terms are, make sure you follow it. I was talking to somebody yesterday about this, that you might get a letter that says, if you pay us $1,000 and by May 15, we'll delete it. And so somebody says, well, John, I paid the $1,000 and they didn't delete it. I go, when did you pay it? They go, October 15. Like, well, you didn't meet the terms. So you got to know exactly the terms. But I have found the original creditors are not real inclined to voluntarily delete it.
Do you have any strategies? Because that's something I get asked all the time is, we'll enter into a settlement, and I've noticed that different debt buyers, and that they're more willing than others to delete. Some debt collectors and debt buyers, they often say to me, well, look, under the Fair Credit Reporting Act, we've got to report accurately. So we are going to report what happened here, that there was a settlement. We're going to show there's a zero balance. There's going to be a notation there that it was settled for less than the amount owed. My counter to that is, you've got to be accurate, but there's also no requirement that you report. So you could delete. Any strategies to kind of twist arms to make that happen? Because I've run into that with some debt buyers where it's non-negotiable. They're not going to delete.
A couple of thoughts. Some of the debt buyers, I think Midland's doing this now, Portfolio. If you pay them money, I think it's on their website, they say, we will delete it. Okay. But if they won't do that, and they're just being stubborn about it, sometimes we kind of, for lack of a better term, reverse psychology. We say to them, okay, great, don't delete it, because I know you're going to mess this up, and then I get to sue you. And so as soon as you make that payment and they collect it and it clears, okay? So if you're in a lawsuit, as soon as they dismiss that lawsuit, if it's, a money order you send them or a check, make sure it's cleared, and then immediately dispute it with the credit bureaus and say, look, this creditor, debt collector, whoever, they know that I owe them zero. And they know that, but they're reporting a balance. So if they won't show it as zero, delete it. Most of the time they will, but we certainly have had lawsuits over that where we get to sue Capital One, Bank of America, Chase, all those types of companies, because they told the credit bureau, oh, no, you still owe $5,000. Well, that's not true, because you took my $1,000 settlement or $3,000 settlement. So sometimes if they start getting nervous that, oh, well, wait, are we going to, does this guy know something we don't know? Then they may say, I tell you what, we're going to delete it. And so sometimes that works. And, but I would definitely want to challenge them on the credit reporting, because usually there's something that's incorrect about it. And that may give you an angle to get it off. Yeah.
Yeah. I like your advice. Make sure you get everything in writing, and don't give money if you don't have writing. So, well, you know what? We're coming up on an hour. And so I think maybe that'd be a good place to end this.
Okay.
John, I appreciate your time. And, I know that we're going to recommend everybody subscribe to both of our YouTube channels. We both put out videos a lot. We put a lot of content out there. I'm trying to keep up with John here and all the videos that he does. But, what's the best place if they want to learn about you, about your practice, to subscribe to your channel? What's the best place for them to go?
Yeah, so probably just our main website, alabamaconsumer.com. So alabamaconsumer.com. I'm not even sure. You probably can just, on YouTube, I think it's Alabama Consumer Protection Attorneys or something like that. Hopefully, if you put my name in consumer lawyer, that'll pop up. And, if you're not subscribed to John's channel, he has very good videos. He has these very catchy titles. I saw one come across a day or two ago, something about, is Dave Ramsey completely wrong about bankruptcy or something? I thought, well, that'll be interesting. So John has some very, very good videos.
Well, I appreciate that. I'm a Dave Ramsey fan, actually. So, but we got to call him out every now and again. But I appreciate everybody watching. My website's consumerwarrior.com, or just subscribe to this channel. And we try to put out videos that deal with all these issues. And if you're watching this after we're doing a live here, go ahead and put more questions in the comment section. I do read over those, try to respond to them, but appreciate everybody watching. And with that, we'll call it quits. Thanks, John.
Okay. Thank you, John. Bye-bye.